Our starting point tonight is the story that quite literally spans continents. The Democratic Republic of Congo has filed criminal complaints against Apple subsidiaries in France and Belgium, accusing the firm of using conflict minerals in its supply chain. The DRC is a key source of what are referred to as 3T minerals: tin, tantalum and tungsten. They're used in the manufacturing of computers and mobile phones, among other minerals. However, some artisanal mines are run by armed groups, especially in the country's eastern end, and they're involved in some pretty heinous crimes. In parallel complaints filed to authorities, the DRC is accusing local subsidiaries of Apple France, Apple Retail France and Apple Retail Belgium of a range of offences. That includes covering up war crimes, handling stolen goods and carrying out deceptive commercial practices. Let's dig into the details of this case. Dr. Akosua Hankings-Evans is an attorney and a lecturer in EU law. She's joining us live on the program tonight. Thank you very much for your time this evening. Let's start with the basics here. What's the legal standing for the DRC to file these cases in France and Belgium rather than going directly to the United States where the parent company is domiciled?
Well, I guess it was a strategic decision to file complaints in Europe, particularly in France and in Belgium. And those complaints are of criminal nature. So it targets the criminal conduct of corporations, and corporate responsibility is much more evolved in European countries oftentimes, in contrast to the United States. Actually, there was a complaint being filed by individuals in the United States that wasn't successful. So I assume that this should counter any concerns as to the success of such a complaint.
Indeed. When you speak about, corporate responsibility being a lot more evolved, I mean, some of the cases that come to mind for me would be Lafarge, for example, the cement manufacturer, being held to account for having paid ISIS, for example, in Syria operations some years ago, or five or 6 years ago.
Exactly. And the European Union is very concerned about corporate responsibility along value chains. A lot of initiatives by lawmakers have been launched with limited success. Nevertheless, it is at the forefront of human rights organizations' list of demands, and we will see how it will further evolve. So chances are way higher in a European context to get justice in that regard, in this case, criminal justice.
I want to get back to the case that you mentioned in your first response. It was initially filed in 2019, and then in 2021, a judge essentially looked at this case against Apple, Dell, Microsoft, Tesla and Alphabet, which is accusing them of benefiting from forced labor in the DRC. And the judge in that case, Carl Nichols, argued that the harm alleged by the plaintiffs, quote, is not traceable to any defendant. So given that outcome in U.S. courts, what does the plaintiffs need to do here to essentially make an iron-tight case saying that illegally mined cobalt in the DRC did directly end up in Apple's hands and the firm knew about it?
The problem really lies in the fact that Apple does not source materials itself. Tesla doesn't source material itself. So it really just is a responsibility to guarantee that value chains remain clean. Now, as you mentioned already, we are dealing with minerals that are conflict minerals. So they are, they appear in conflict regions, and it is inevitable that harm encompasses the extraction of such minerals. So the question really is, what laws can we develop to maybe shift the burden of proof in such situations? But it was really, in fact, that also according to Apple itself and all its reports filed with the SEC in the United States, that its value chains are, on paper at least, clean.
Indeed, and that leads me to my next question, because as you say, Apple does these reports, these audits of its supply chains every year, and so far they say they've removed 26 companies, 14 last year, 12 the year before, which refused to take part in that audit process. That gives us a sort of sense of the sort of defense that Apple could use if this does go to trial, doesn't it?
I think evidence will be crucial in that regard, and also maybe establishing some kind of due diligence obligations on the part of the companies. And this is why a complaint in Europe makes more sense. There are certain assumptions drawn from the fact that a company didn't act or didn't further investigate. What is interesting in this case particularly is that the complaint also, in the case of Belgium, ties Belgium's engagement or Apple's engagement to the colonial past of Belgium, and thereby also states that Belgium has a special responsibility in making sure that harm doesn't happen again.
Indeed. Let's see how this plays out. It should be a very interesting case to keep
Definitely.
an eye on. Dr. Akosua Hankings-Evans joining us there live on the program. She's an attorney and a lecturer in EU law.